Welcome everyone, this is Amer from U Council. If you want to understand only one thing in Canadian employment law, then it is the concept of reasonable notice of termination. It is the single most important concept that has strong bearing on your employment relationship, whether you are an employee or an employer. So we'll talk about what this reasonable notice is and what does it mean to you, and we'll explain it in simple terms so you can apply it in your own circumstances. Before we begin, we'll start with our usual disclaimer that this course is not legal advice, so if you have any specific questions, you must contact a lawyer or a paralegal. Why is reasonable notice important? Well, basically, reasonable notice is important because it may translate into significant amount of money. If you're an employer, you may end up providing a significant amount of money to your departed employee, and if you're an employee, you may be entitled to a large amount of money. So the relevance of reasonable notice is directly related to the money that you may get on termination. Two things you must keep in mind. So with respect to reasonable notice, if you are terminated without cause and you are entitled to common law rights on termination, in that situation, once those two conditions are fulfilled, then you are entitled to common law reasonable notice of termination. And just to give you a perspective, this reasonable notice could be as high as 24 months of income. So if you make $100,000 income annually, then sometimes if you meet the criteria, you may be entitled to up to 2 years of your pay. So that's a significant amount of money on termination when you're actually losing your job. So what is this reasonable notice? The main thing you want to understand is that the term reasonable notice, it's called reasonable notice commonly, but the proper term is common law reasonable notice of termination. And so what is this? It is a notice that an employer provides to an employee and basically tells the employee that his or her employment is going to end. And so this common law notice or termination notice could be given in one of three ways. So option number one is working notice. Employer can come to you and say, hey Mary, hey John, your employment is going to end, is going to terminate as of December 31st of this year. So let's say 12 months from now. And I am giving you this working notice. You are required to come to work every single day as if you are an employee, perform your duties, we will provide you your salary, and when December 31st comes, that's your last day, and then you go home and never come back, and then you don't get any more money. This is it. So it's a working notice. You worked the entire 12 months or whatever the duration of the reasonable notice is, and then you go home and that's the end of it. So there's no money at the end of it. Or the employer may say, hey John, hey Mary, your employment is ending today. So return your keys, return your access cards, and then at the end of the day you go home or you leave now and you do not come back. And here is the money for 12 months of your pay. Or they may say, we'll continue to give you salary for 12 months until you find another job or something like that. So, but the termination happens immediately, and then you get the money for the notice period. So that's option number two, which is actually the most common option. Most employers do not like to retain an employee on their premises who knows that his or her employment is going to end sometime in the future, because it makes it difficult for that employee to continue working, knowing that he or she is going to lose his or her job in some time in the future, and there's a date that has been announced to that person. And also it may jeopardize the relationship, it may poison the work environment. So majority of employers do not like to give working notice. Sometimes it works better and employers do that, but mostly the employers do not give working notice, that they would rather give you money in lieu of working notice. Or option number three is a combination of both. So the employer can give part of working notice and part of money in lieu of notice. So employer may say, it happens sometimes when the factory is closing, the plant is closing down in 3 months time, and your reasonable notice requirement is, let's say, 12 months. The employer may say, we expect you to work for the 3 months. So 3 months is the working notice, and the remaining 9 months will give you the money. So it could be working notice, it could be money in lieu of working notice, or money in lieu of notice, or it could be a combination of working notice or money. So that's what a reasonable notice is. It is an information, it is a notice that is provided by the employer to the employee, providing that employee a specific date, which will be the final date of employment of that employee. So notice of termination. So we talked about common law rights. So you are entitled to reasonable notice if you are entitled to common law rights. And we're talking about common law reasonable notice. We're not talking about the statutory termination notice, which is a completely different thing. So what important part you want to understand is that you get common law rights by default. The common law rights are presumed. What do I mean by that? If you get hired with a company, and let's say you don't have any written job offer, written employment contract whatsoever, somebody interviews you and says, welcome, we're going to pay you X amount of dollars, and this will be your position, and can you start on such and such day? And you answer yes. And so that is an employment contract, even though it's verbal, but you have entered into it. And when you have entered that employment contract, then you by default have all the common law rights. And that means if you are terminated, in the specific circumstances of this course, if you are terminated, then you are by default entitled to common law reasonable notice of termination. But the second thing you want to keep in mind is that common law right, or the reasonable notice of termination, that presumption is rebuttable. What that means is that presumption can be displaced by a contract. So if you have a written employment contract, the employer can put in a clause which can change your common law right on termination. So it can take that away. So it can remove that reasonable notice by contract. And so how it's done, we're going to talk about that in the next slide. So displacing common law reasonable notice. One way to do that is the contract may say, your employment contract may say, first of all, it will have a specific termination clause. It will say, if in the event we terminate your employment without cause, you will be entitled to your statutory termination rights and nothing more. So we are limiting your rights to statutory rights on termination. And we've spoken about that in a separate lecture, and maybe we'll talk about it a bit more. But each province has a specific statute that deals with employment relationship, termination, and all of those, and they have specific rights for the employees. So for instance, in case of Ontario, we have Employment Standards Act 2000, which has a specific clause that says that if you're employed for X amount of years, you get X weeks of pay as termination pay. So those statutory rights are very, very minimal. There's no comparison between the statutory rights in Employment Standards Act and common law rights. So there's a huge difference. So a contract can actually take away your common law reasonable notice and say what you will get is only statutory rights, and that's legal, it's allowed, an employer can do that. So that's one way of doing that. The other way is that the contract may say we retain your common law rights. And if the contract retains your common law rights, then that's what you're entitled to. Or the contract may not have any clause about termination whatsoever. And if there's no termination clause, then the presumption is still there, and so you're still entitled to common law reasonable notice. The third way that employer can do is give you something in between. So more than statutory rights, but not common law rights, right? So they may say, we'll give you your statutory rights plus 2 weeks or plus a month or something like that, which may be much less than common law rights, but it is at least more than your statutory rights. So that could be a clause in your employment contract. Or in some cases, which is very, very rare, but in some cases, your contract may provide your termination rights, which are actually more than common law rights. I have seen this, and you may have noticed this. This usually happens mostly in appointments which are political appointments. You would see in newspapers that a large sort of crown corporation or crown corporation have been working, and it's in the news. The CEO did not perform so well, and they terminated CEO's employment. And then you realize that CEO got hundreds of thousands of dollars or sometimes millions of dollars in termination as a severance package. and everybody's up in arms, but the answer that you will get, legal answer that you will get is, unfortunately, that was part of his or her contract, and so there's no way that we can take that away. So there are circumstances where the termination rights are negotiated much more than common law rights, but it's very, very, very rare. You won't see it as, and my experiences is sort of these political appointments where this kind of thing happens. So these are some of the ways that contract can displace the presumption of reasonable notice. Now, I said you could get up to 24 months of pay, and not everybody can get that, and that's sort of an extreme example. But what are the factors that you can keep in mind that decide, or the courts, what kind of factors courts consider in deciding what is an appropriate common law reasonable notice for a specific case? There's no formula, there's no one reason. There are a variety of factors that the court considers and then decides what would be an appropriate common law reasonable notice for this employee who has been terminated without cause. So these factors, there's a case in which these factors are basically listed, but they talk about more factors to be considered, and they're called Bardal factors. This is the term that is used in a case law, and employment lawyers use this often. Every time they refer to Bardal factors, those are some of the factors that court will consider in deciding reasonable notice. So when you look at the cases, the jurisprudence, the courts have considered as many as about 170 different factors in arriving at what is an appropriate reasonable notice. But there are four most common factors that you want to keep in mind. Those are the essential ones that would apply to every single case. So number one is age. What is the age of an employee who has been terminated? And the formula here, or the thought process here in court's mind, is that the older the employee is, the more the reasonable notice of termination should be. Courts believe that it will take older employees longer time to find another job as opposed to younger employees. So their reasonable notice of termination on the basis of their age, or age, will play a role in an increased reasonable notice. Second factor to keep in mind is length of service. The longer the employee's service with the employer is, the longer the notice period would be. So if you're a long service employee, then you will get higher notice. And I have had clients who have worked for an employer for 20 years plus, and they may be entitled to 24 months of pay depending upon their other factors. Third factor that is considered is the position. And the way this works is, what is your position? Are you a senior management employee? Are you a management employee, middle management, lower management, clerical, technical, engineering kind of person? What is the kind of position you're occupying? And then the principle that the court applies generally is that the higher the position of the employee, the higher the notice period. So if you are a CEO of a company, you will probably get higher notice than if you were a much junior employee. And then the fourth factor is, what are the chances of finding another job for that specific employee? And there's no sort of empirical evidence generally available, but there are different factors considered. So I'll give you an example. Some time ago, there was significant reduction in automotive industry jobs, and whatever jobs were being eliminated, there were no alternative positions. And so many engineers who had automotive industry experience for many, many years had to retrain to go into another job. So that was a factor that for them, chances of finding another job in Canada in the automotive industry was slim, and so the court would award higher notice. So those are some of the factors that court will consider. So these are the factors that courts will consider in deciding what would be an appropriate reasonable notice. And as I said, it could be as high as 24 months or sometimes even a bit more. So what is it that you want to carry from this course, from this lecture, is that when you are negotiating your employment contract, you are not hired yet, you are a candidate, you are at a stage where the employer is making you an offer and has provided you with an employment contract. And if you have any room to negotiate, sometimes you don't, sometimes you just accept, you're just happy that you got a job and you just sign at the dotted line and you take the job. But in many, many cases, you have room to negotiate. And if you do, you want to make sure that your common law termination rights are not displaced, they remain intact. And I've advised many of my clients when they have been faced with a job offer and they have successfully negotiated that position. Because if the employer really wants you for that position, if the employer believes that you are an important addition to their team, then they will value your negotiation, and they will value that you are going to look after some of your own interest in that employment contract. And then the second part is that even if you already have an existing employment contract, or you're not able to negotiate something different, you want to make sure that you properly review your existing employment contract, because even if it has a termination clause, in many cases that termination clause may be challenged, may be shown or may be proven that it's unlawful, it's improperly drafted, and then that will not rebut the presumption for common law notice, and you may be still entitled to it. So it's a complex area in employment law, which termination clauses are valid and which are not. And if you talk to many employment lawyers, they will give you the advice that over 90%, 95% of the time, smart employment law counsel are able to challenge the appropriateness of a specific termination clause, get it thrown out, and then have their client get some reasonable notice. So something that, if you are unclear, if you're unsure, you want to talk to an employment lawyer so you understand your rights, because what is at stake is a significant amount of money. So those are two things that you want to keep in mind, and hopefully this gives you some understanding of what is common law reasonable notice. We'll have many more lectures. If something is unclear or you want something elaborated upon, by all means reach us out, write us in comments, and we'll be happy to cover that in future lectures. Thank you for watching.